Welcome. My name is Raul Melendez, and this is MPA545 Conflict Resolution and Labor Negotiation. Today, we'll be discussing four hybrid judicial alternative dispute resolutions processes and how they function within public conflict management and competitive bargaining. I will examine early neutral evaluation, dispute review boards, mini trials, and summary jury trials. For each process, I will briefly explain how the textbook describes it, and then compare that with a journal article to highlight similarities and show how the research expands on the topic. I will then conclude with a focused news analysis on early neutral evaluation to demonstrate how one of these hybrid processes operates in a real world setting. According to Eisenhart and Spangle 2000, early neutral evaluation involves a court appointed neutral who provides a non binding legal assessment early in a case. The goal is to help both parties understand the strengths and weaknesses of their positions before litigation becomes more costly and adversarial. Brazil 1987 describes early neutral evaluation in a similar way, emphasizing its roles in promoting early settlement and reducing unnecessary proceedings. Both sources highlight the early neutral evaluation is binding and designed to encourage realistic negotiation early in the process. However, Brazil expands on the uh, textbook by highlighting institutional benefits, particularly improved docket management and reductions in court backlog. This shifts the focus from individual dispute resolutions to a broader judicial efficiency. Dispute Review Board. Eisenhart and Spangle 2000 explained that dispute review board are panels of experts used primarily in large infrastructure projects to address dispute as they arise. Harmon 2003 reinforces this, but emphasizes that financial and governance impacts of dispute review boards, especially in public construction settings. Both sources describe DRBs as preventative mechanisms designed to resolve issues before they escalate into litigation. The journal article expands the discussion by focusing on cost control, risk management, and the protection of public investment. Mini trial. The textbook defines that the mini trial is a structured voluntary hearing where executives hear abbreviated case presentations in an effort to reach settlement. McGovern, 1986, similarly describes mini trials but frames them as strategic tools for managing complex litigation. Both sources emphasize efficiency and the goal of avoiding a full trial. McGovern expands on the topic by showing how mini trials can serve a broader litigation management strategies in high stake disputes. Summary jury trials. Eisenhart and Spangle explained that summary jury trials involve presenting abbreviated cases to a mock jury and that jury that delivers a non-binding advisory verdict. Lambros 1984 describes summary jury trial as a reality testing mechanism that helps parties reassess the strength of their cases. Both sources agree that the advisory verdict is intended to promote settlement rather than impose a binding decision. The journal expands on this by examining the psychological impact of jury feedback on negotiation behavior. News analysis on early neutral evaluation to demonstrate how hybrid alternative dispute resolution functions in real world practice. I examined a 2025 article by Swenson discussing efforts to strengthen early neutral evaluation programs within court systems. In this article, Swenson 2025 explains how courts are actively working to expand early neutral evaluations through judicial leadership, structured program design, and increased attorney participation. The article emphasizes that successful implementation requires collaboration between judges, attorneys, and court administrators. This reinforces the description provided by Eisenhart and Spangle 2000 who define early neutral evaluation as a court connected, non binding evaluation process designed to promote early settlement. While Eisenhart and Spangle focus on the structural framework of the process, Swenson expands the discussion by illustrating the practical challenges of implementation and the importance of institutional commitment. What stood out to me from this article was the emphasis on institutional buy-in. Swenson makes clear that early neutral evaluations effectiveness depends not only on procedural design, but also on trust, cooperation, and consistent application within the judicial system. In conclusion, hybrid judicial alternative dispute resolution processes blend formal legal authority with collaborative negotiation strategies. Across all four mechanisms, the journal research reinforced the definitions provided by Eisenhart and Spangel while expanding the discussion to conclude or to include institutional efficiency, fiscal responsibility, and behavioral impact. These processes promote efficiency, reduce litigation costs, and help protect public and institutional resources. Ultimately, hybrid alternative dispute resolutions serve as a modern and effective tool for managing conflict within the judicial system and public administration. And here is a slide for my references. Thank you so much for watching.